Resources Manual on hrsimple.com. Heather does, actually. And Cozen O'Connor also authors the New Jersey, New York, and Pennsylvania Human Resources Manual. So we're happy to have them here today. All right, a few quick announcements. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. HRSimple.com is an HRCI approved provider and a SHRM recertification provider. At the end of this webinar, we'll give you codes to get your credit. Please enter your questions in the chat box, and Heather or I will get to them when we can. A recording and slides will be emailed to all registered attendees after this presentation. I'll probably also post up the slides at some point during the presentation as well in the handouts section. We're also posting all of our webinars to youtube.com/HRSimple. All right, now just to give you a little info on Heather Marx, today's speaker from Cozen O'Connor. Heather Marx applies her experience in the areas of complex business and commercial litigation to represent a variety of clients. Her practice includes the representation of corporations, individuals in real estate and leasing issues, bankruptcy adversary proceedings, commercial transactions and disputes, and issues of employment law and benefits. Heather handles contract disputes, commercial and private loans in regard to both enforcement and defense of loan and mortgage obligations, business liquidation distribution, lease obligations, receivership appointments, real estate transactions, insurance claims, import-export contracts and litigation, and employment termination disputes. Further, Heather's experience in bankruptcy litigation includes years of representing both debtors and creditors in significant adversary disputes and workouts, including clawback litigation, both in Minnesota and in other states. So we're happy to have her here today. So if you're ready, Heather, you can go ahead and just get started.
Thank you, Eric, and thanks everybody for taking time out of your day to attend the seminar. I know that it's always hard to find time during the day to do these, but this is a good one. And what my bio probably doesn't tell you is that the labor and employment part of my practice is truly my favorite part of my practice, because it has practical application and it has immediate impact both on employees, on employers, and it's a really fascinating part of the law. So I'm happy to talk with you today about recruiting and hiring issues. And if you have questions as we go, please feel free to jump in the chat box as we're going. I think it always helps if I can answer the questions while we're still on the topic, so feel free to sprinkle them in as they come up. Certainly we'll leave some time at the end, hopefully, for questions at the very end. So whenever you have questions during or after, please feel free to jump in with those. If there are questions that come up to you after our seminar is done here today, please feel free to reach out to me directly, and I'm happy to try and answer those for you as well. Turning to the issue that we're looking at here today on recruiting and hiring, steps in recruiting and hiring, and looking at the bios of you that have registered, it looks like you're all very familiar with it. And what's interesting about recruiting and hiring is that the steps that we take to attract applicants and hire them become routine. And like anything we do routinely, we can develop habits, and it's important from a legal perspective not to take these preliminary steps for granted, because if we develop bad habits, those can really expose your company to liability. This is an area of changing law, so this is not anything that's set in stone, so you're doing your company a great service if you stay on your toes and keep yourself updated in these particular areas of law. So my goal in the next hour is to give you some insight from having dealt with these issues in the litigation context of how you can foster good habits and keep your company compliant with developing law. So the very first step in the process is we're looking to how do we recruit applicants? How do we get people in the door to try and apply for employment with our companies? There are certainly a number of methods that are available for an employer to recruit job applicants, and that things like internal job postings, employee referral programs, advertisements, and certainly with the increase of social media and the omnipresence of the internet, we've got postings on the internet, we've got postings through social media sites. There's the use of professional employment and temporary employment agencies, and even some more formal recruitment programs at local schools or community organizations. And I think what you need to recall is that regardless of the mechanism, you have to describe and advertise what position it is your company needs to fill. Seems pretty straightforward, but you can go off track even in these early stages when you're putting together a job advertisement. So whether it's a job posting, an internet posting, an advertisement, there are certain things that what I'm going to call the job advertisement should include, and things that there shouldn't include. Advertisements should be designed to attract candidates, and they should be carefully drafted to avoid any indication of discrimination. If you have an advertisement that's carelessly drafted, even if it's unintentional, you can expose your company to claims of discrimination. And in particular, if your posting makes reference to an applicant's race, sex, religion, national origin, age, family status, sexual orientation, or status in regard to a disability, these are protected classes, and these protected classes, frankly, in our society today are developing and expanding, so it's something to keep an eye on. Let me give you a real-world example. If you put together a job advertisement seeking, quote, recent college graduates, or someone who is young and energetic, that has actually been found to have a discriminatory effect against older persons. And similarly, if you've got a job posting about a language and an advertisement that specifies a physical ability that's required for the job, even something that seems innocent, like a clear speaking voice or a language proficiency, that has been found to discriminate against the disabled or particular ethnic minorities. So when you're using the internet to advertise, consideration should be given to the application of laws in other states. So not only do we have the federal laws about discrimination, we've got each state has its own individual set of laws as to what can and can't be included in the ad. So you put all this together, and when you're preparing your job advertisement, an employer should clearly and concisely describe the position and describe any qualifications for the position without making reference to the personal attributes that are usually associated with a protected class. Again, not mentioning race or gender or age. And it's also generally a very good idea to include a statement in advertisements that the employer is an equal opportunity employer. And while that's a good idea for most of us, there are even some employers where that's mandatory, like a federal contractor or subcontractor. So we know what the application or what the advertisement is going to look like now. So take the next step in the process. It's the job description. What is it you're looking to hire someone for? So once you've established the need for a new employee, one of the most important aspects of screening and selecting that new employee is to develop a job description. You want to clearly define the essential requirements and functions of the position. This is of particular importance in cases where applicants might have disabilities, because a job description that predates the applicant's application, it's going to provide your company evidence that the job requirement isn't just a pretext to exclude particular disabled individuals. For example, again, I like real-world examples because they help us understand, what we can and can't do. If you have a job that's going to require an applicant to be exposed to certain ambient temperatures, I'm in Minnesota, I think of the weather often. If your job applicant is in Minnesota working outside, you're going to want to include that in your job description, because an applicant could potentially have medical sensitivities that would preclude them from working outside. So if that is the case for your job, include it in the job description. The exposure to ambient temperatures or other conditions that might serve to disqualify applicants with particular disabilities. You cannot eliminate the disabled, but you can describe the job so that anyone who applies must be able to meet these certain job descriptions. In addition to providing the obvious purpose of identifying the employer's hiring needs, the job description performs an important legal function. It provides an objective standard by which the applicant's qualifications can be measured. Provided that the standards are lawful and they're applied even-handedly, an applicant who doesn't meet the stated standard doesn't have the basis for a claim of unlawful discrimination. If they can't do the job that you've described, they can't bring a claim for discrimination. So the job description becomes an important document in the event of a dispute between the employer and the employee, and it always should be maintained in the permanent employment record. I'm going to repeat that because it's terribly important for all of the files that you maintain. Whenever you use a job description to hire someone, a copy of that job description should be placed in the employee's permanent file. It should be maintained as long as the employee maintains his or her employment with the company, because that provides you the objective measure as to whether that employee is or isn't performing their job. Okay, so we've gotten through the first two steps of the process. You've posted for the job opening and you've created the job description. Next in the process, how do you screen the people that come in? How do you effectively take this pool of applicants and decide who's best suited to fill that job description that you've posted? A lot of employers use a job application, and again, this gets back to, we take certain things for granted that there is a job application, but legally a job application isn't required. You can interview applicants without using a job application. A lot of times that's practically unreasonable because you're going to have so many applicants that you have to develop some sort of screening mechanism. But you should know that job applications aren't legally required. The employment application is a good starting point for finding the most qualified candidates, and it does allow employers to compare multiple applicants across the same range of qualifications like educational level or workplace experience when they're performing the initial screening. And whether the employer uses an application or some other means of collecting information, what you have to make certain of is whether it's an application or some other form, when you're collecting information, you have to make certain that you're only seeking information that's required for the position for which the individual is applying. Again, this is a reason that we've taken such care in drafting the job description, because you're only going to collect information that's relevant to that job description. Under the ADA, the Americans with Disabilities Act, employers must provide an equal opportunity for disabled applicants to participate in the application process. Employers that are subject to the ADA have to therefore make reasonable accommodations, even at this job application stage, to allow for disabled applicants to complete an employment application. The reasonable accommodations that you offer an applicant don't have to be made in advance, and they can be made simply when an applicant comes in and requests accommodations. Examples of the type of reasonable accommodations that might allow a disabled applicant to complete the job application would include things like providing the job application and information in an accessible location, or providing the job description and application in large print. Those are type of very simple accommodations that can be made in response to a request that will keep your company compliant with the ADA, even at this preliminary job application standpoint. In the job application, if you're going to use one, and again, they're very handy tools. I just want to make sure that if you're going to use one, that you're using one that complies with all of the legal requirements. Generally, an employment application should contain things asking for your name, address. You can ask for a social security number, education, employment history, references. You can ask for the names and contact information for past immediate supervisors. You can ask the reasons that they've left their prior position, and you can ask, what their educational history contains. If you choose to use an employment application, you can also ask whether the applicant is legally eligible for employment in the United States. And unless it's a contract position that you're filling, an employment application itself should indicate that it's not an offer of employment, it's not a contract, and that if hired, the employment will be at will. It's important that your job application have these disclaimers. I know a lot of people look at the disclaimers as legal mumbo jumbo, but these are two disclaimers that are going to keep your company in very good standing. The application should also include that statement that your employer is an equal opportunity employer and won't unlawfully discriminate. Okay, so that's a little bit about what you should ask. So we need to look at the flip side of the same coin and examine what you cannot or should not ask on a job application. Because there is some information that an employer really must avoid asking on an employment application, or through any means of communicating. So if it's not a formal application, if you're just communicating with a prospective employee, you can't ask certain information in any way, shape, or form. So absent unusual, very, very unusual circumstances, the following topics, and there's quite a list here that I'm going to run through, they really should be avoided because inquiries on these topics are prohibited under state or federal law, and it could lead to your company being exposed to claims of discrimination. So don't ask applicants about their race, color, creed, their age, although it is permissible to ask if the person is above a minimum working age that you have for the position. You shouldn't ask about their religion. You shouldn't ask about their sex. And this is interesting because as the law continues to develop, the inquiries into gender go so far as to look at those traditional boxes where you ask the applicant to check Ms., Miss, or Mrs. If an applicant really wanted to raise an issue, that's one way that they could raise an issue, is saying that those simple check boxes make an inappropriate inquiry into their sex. So if you're looking at your job application with fresh eyes, take those boxes off, along with any other inquiry that directly or indirectly asks about an applicant's sex. You can't ask about an applicant's disabilities or physical limitations. You cannot ask them about their national origin, their birthplace, their native language. You can't ask about any medical conditions or genetic information. You cannot ask them about their economic status, including any past bankruptcies or credit issues. You cannot ask them about marital status, their children, pregnancy, child care arrangements, their names or addresses of relatives. None of this should be on a job application. You also, interestingly, should not ask them about workers' compensation claims or prior injuries. Veteran status, simple things like weight and height, those don't usually have anything to do with the job application, so those, or with the job description, so those should be off the table. You can't ask them about garnishments. We're going to talk in just a moment about prior arrests and convictions. That's a very hotly developing area of law, so that probably should be left off of the job application at this point in time. And you cannot ask an applicant about prior labor union activities. So when I was talking just now about criminal history, one of the biggest trends in employment law is this Ban the Box initiative. It's something that we've seen in Minnesota here beginning as of about January 1st, 2014. And under this theory, under this law in Minnesota, employers can't ask about an applicant's criminal record or even conduct a criminal background check until later in the hiring process, like at the interview stage or when a conditional job offer has been extended. And in Minnesota, they explain that this Ban the Box law is designed to provide job candidates who might have an arrest or conviction record with more opportunities to be evaluated on their skills and experience when they're applying for positions. Some additional rationale that we've seen in other states for this type of legislation is to provide applicants with convictions and a better chance of employment. It's designed to address disparity among ethnic groups with criminal records, and in some places like Minnesota, it's designed to expand a shrinking workforce. So the statute, as it is in Minnesota and in many other states, requires that an employer cannot interview you cannot inquire as to an applicant's criminal history unless the applicant has been selected for an interview. So after the applicant has been selected in an interview, you can ask them. You can ask about their criminal history. And in practice, you should do that in writing, and it has to be after the interview, at or after the interview stage. So we're still talking about job applications. In my view, in this day and age, an inquiry into prior criminal history has no place on a job application. It's just an invitation for trouble for your company. One of the questions that just popped up that I want to address is, looking back to the application stage, can you ask an applicant if they're a smoker? Could this be a gateway to socioeconomic status? My answer to both of those is yes. It is an issue, and it is a potential indicator for socioeconomic status. So I would steer clear of that on the job application. I think that it also potentially makes an improper inquiry into their medical history, because a lot of times if you've got a candidate who has a history of smoking, they're going to have increased medical insurance claims and premiums, and some employers try to look at those, look at that history of medical issues and try and use that as a reason to keep a potential applicant out of the job pool. So I think that there are many potential reasons to keep a question of are you a smoker off the job application, and frankly I can't think of a good reason that you would ask that either at the job application or the interview stage. I think it just invites too much trouble as far as inquiry into medical history or socioeconomic background. So Mike, I hope that that answered your question. Shifting back to the criminal history, the ban the box issue, employers, you can still include a criminal history, but to be compliant, you have to wait until the later stages of the application process to do that. You know, it's good practice for employers to do it, especially if you're a multi-state employer. Just wait. There's no harm done in waiting until the application, the post-application interview stage to conduct a background check. If you feel that that's relevant to fulfilling the job application and you want to disqualify an applicant after the criminal history portion is done, you can still do that, but it's no longer legally permissible in most states to do that at the pre-interview stage. So especially if you're working for a multi-state employer, I think that that's just good practice to do away with any inquiry into criminal history at the application stage. So I think if you take only one thing away from today's seminar, it should be this: you're doing your company a great service to stay on top of this issue. Take the criminal background inquiry off the application and just do it later. So now we've gotten through those initial stages of posting our job opening, we've developed our job description, we've put together a very compliant job application. You know, hopefully you have a multitude of great applicants to look at, and now you're at the interview stage. You would be truly amazed at what gets asked in interviews, and this is really a key area where bad habits start to show themselves. Interviews have a distinct effect on the hiring process, and it's an extremely important part of recruiting and hiring because it truly enables the employer to convey important information about operations and learn valuable information about an applicant. But it's also an area that's ripe for potential discrimination claims. So it's really critical that as an employer and HR manager, you understand what types of questions should and shouldn't be asked during an interview. So in light of all the beneficial information that can be obtained about an applicant during a properly conducted interview, and also balancing the issue of potential legal claims that can result from an improperly conducted interview, I really recommend that employers centralize the interview function to the extent that it's possible and allow only trained people like an HR professional to conduct an effective and appropriate interview. Employers who don't have that luxury of centralizing interview responsibilities with a full-time HR professional or their high-level official, they should conduct training. It's so important to develop and distribute checklists and make sure that the people who are doing your interviewing understand what they can and can't ask. If you put together the training or centralize the interviewing function, it helps the employers be aware of the inquiries that are proper as well as those that aren't permissible in an interview setting. So we've got the who. So what should those people be doing in order to properly prepare for an interview? You really shouldn't wing this stuff. That's why we ask that to the extent you can, you centralize the interviewing function with an HR professional. Prior to any interview, it's good practice for an interviewer to go back and read through the relevant job description. Identify what are the essential job functions, any relevant policies that your company has, and the application form and the applicant's response, as well as a review of the applicant's resume and references. By reviewing all this information prior to the interview, the interviewer can be sure to ask specific and focused questions designed to obtain the information about the applicant's employment history and job qualifications and determine if that applicant is a good fit for the position. If you're going to conduct an interview, do it well, do it wisely, and get the information that you need. To that end, many employers find it helpful to develop structured interview formats so that applicants for a particular job are asked an identical set of questions against which they can be evaluated. If you're using that type of interview form, that reduces the likelihood of discrimination claims, and it does it in 3 ways. It makes it less likely that any disappointed applicants can prove that questions were tailored to them based on some protected class. It also increases the likelihood that the employer can point to specific comparative reasons why it preferred one candidate over the other. And again, that structured interview format also enables more meaningful comparisons. You're comparing apples to apples because everybody has answered the same questions. It allows that decisions to be made based on the objective criteria, and it really eliminates any potential exposure that your company might have for job discrimination in the interview process. It is fine to take notes during the interview. I think that makes sense as a business practice, so feel free to take notes. Employers can make notes about an applicant's general appearance, things like professional or unprofessional. You can make notes about an applicant's interpersonal communication skills, their attitude, other subjective factors that concern the applicant's ability to perform the job in question. All of that being said, please, please, please be careful about the types of notes you write down concerning an applicant, because everything that you write down during the interview stage is very likely subject to disclosure if the applicant brings any later lawsuit or alleges discrimination. You would be shocked to see the type of notes that I've seen that I've had to disclose to other sides from my clients' HR managers, just because they don't think ahead to realize that every note that they take during the interview process should be maintained and then is subject to disclosure. It's not subject to any sort of protection. There's no privilege that allows me to keep it from production. So if you take really unprofessional and legally inappropriate notes during an interview, I can guarantee you that an applicant who's displeased and brings claims of discrimination will make that Exhibit A. So feel free to take notes. Just make sure they're professional notes, that they address the issues that the job description addresses, the functions the applicant needs to fill. All of that is entirely fine. Just recall that there is the potential that someone else will see them down the road. Okay, if I could script this for everybody, I would love to, because the questions that I've heard people ask during your interviews range from the questionable to the truly bizarre. So what I want to do is give you just some templates about what you can. It's kind of a choose this, not that sort of approach. You can ask an applicant, are you age 18 or older? Or if your job description requires them to be a certain age, if they're working with alcohol and have to be age 21 or older, you can ask that question. Do you meet that essential job function? Are you 18 or older? You should never be asking a candidate, what's your date of birth? Because, as you can imagine, that opens up the potential for age-based discrimination claims. You can ask, are you legally allowed to work in the United States? And in fact, if you get an applicant that you want to hire and you actually do hire, we'll talk about it at the end that you do actually have to, the applicant or the employee at that point in time has to provide proof of age and ability to work post-hire. It is not okay pre-hire to ask them for proof of age or ability to work. You can ask them the question, are you legally allowed to work in the United States? Don't ask them, where were you born? Are you a U.S. citizen? Again, I think if some of you go back to your straightforward job application, or if you have an established interview protocol, you're going to be surprised to find how many of them ask, are you a U.S. citizen? That's no longer okay. Take that off of all of your job applications and take it out of your interview questions. Go back to the question, can you legally work in the United States? That will keep you safe. Is there any, you can ask them, go ahead, is there anything which would interfere with your attending work regularly? And that's a fair question, because in almost every instance, regular attendance at a job is going to be an essential function of that job. On the other side, don't ask them, and I have in my slides here to women, but really it's to men too. Do you have children? Are they in daycare? A lot of employers will try and use that as a way to understand if they're going to be at work regularly. That's simply not okay. It can be construed as gender discrimination. In the same regard, you can't ask about, like we'll see on the next slide, healthcare issues. You know, are you going to be able to make it given any health conditions that you have? All of those are really off base and should no longer be asked in interviews. Go back to this question I've given you. Is there anything which would interfere with your attending work regularly? It's a safe question. It gets to the essential job function of regular attendance without touching on any potential discrimination in regard to gender or medical status or family status. When all else fails, this is truly a standalone question that you can ask. Can you perform the functions of this job with or without reasonable accommodation? Do include that phrase that I've given you there, with or without reasonable accommodation, because under the ADA, if you've got an applicant who can fulfill the functions of the job with a reasonable accommodation, that applicant should be considered. Conversely, you shouldn't, like I was talking about in the last slide, you should not be asking, have you ever been hospitalized? How many days of work were you absent due to illness? Those are potential discriminatory questions in regard to medical status. You should also not be asking any interview questions that ask, do you have any prior drug or alcohol problems? Because in many states, that inquiry is also falls under the umbrella of disability discrimination. Only if it's required for the job can you ask, are you fluent in a certain language? If you're staffing a call center and you need someone to answer the phone who's fluent in, say, Spanish, you can ask, are you fluent in Spanish? Because that's an essential job requirement. You cannot ask, what's your native language or how did you learn Spanish? I've got a question coming in, Lori, asking, what if you're a federal contractor and you're required to post the EEO clause in the advertisement about race, color, then you have to post it. The federal contractors are subject to a pretty high scrutiny, a pretty high level of information that they have to include in job applications and job descriptions. So pretty much any time that you're posting anything or you're publishing anything, you're going to be able to fulfill the requirement. Include it. When in doubt, include your EEOC clause, because you're never going to go, you can never do it too much, but you can do it too little, particularly if you're a federal contractor, Lori. So, early and often, and I would say anytime, certainly anytime you've got anything in writing, I would include that, because federal contractors, as you can imagine, are subject to pretty great scrutiny there. I hope that answers your question, Lori. Going back to some more interview questions, do's and don'ts, you can ask, what's your current address? You cannot ask, do you own or rent your home? Similarly, don't ask applicants, how long have you been at your current address? I would not ask anything about prior addresses. Unless somehow it's directly relevant to the job that you're filling, it can be construed as discrimination based on socioeconomic status, like the question we had earlier from Mike, or inquiry into family status. So asking about current address, perfectly okay. Asking about owning or renting a home, how long you've been there, not okay. Who were your prior employers? Perfectly acceptable. You can ask for references from prior employers. In asking for those references or in fleshing out information about prior employment, please don't ask them if they were ever a union member. That will get you into a hornet's nest very, very quickly. You can ask them based on the job description, can you perform this job? You can ask that of any applicant, whether they are, obviously disabled or, have some other very palpable impairment. It's still okay for you to ask them based on the job description, can you perform this job? You cannot ask any more detailed information about medical history. You can't ask, for example, if they have a caregiver, even if you're trying to be really sneaky about figuring out whether they have a caregiver by asking something like, oh, who lives with you, or things like that. You cannot ask for that information. Similarly, if you have a female applicant who is applying, you're interviewing for a position and you're really in that unenviable position of trying to figure out whether she is or isn't pregnant, first of all, don't ask that question. It's never going to, it's not only socially inappropriate, it's legally inappropriate to ask an applicant are you pregnant? Go, if in doubt, if you're interviewing someone who may or may not be pregnant and you think that that's relevant to whether they'll be able to fulfill the job requirements of the job you're hiring for, go back to my stock question here. Based on our job description, can you perform this job? And I've included just kind of these sample interview questions, but just to give you an idea, there are some pitfalls even in basic information, in basic interview questions. Hopefully you'll have a resume in front of you. You don't have to ask their name, but if you're asking their name, please don't ask them for maiden names, because unless it's directly relevant to your job description, which would be hard to figure out why. If you're asking for maiden names, they could argue that that's being used to discriminate based on national origin, because you're trying to figure out what their inherent ethnicity is, or family status. So if you need to, if you've got a candidate in front of you and you need to figure out if they are married and potentially have prior employment or prior education under a different name, ask that question. Say, if any of your employment or education was under a different name, can you give that to me? We're going to go for different rather than maiden. So it asks the question that you need to ask, but in a very appropriate way. So, if we can tell through all these do's and don'ts that interviewing there are very real pitfalls that exist. So you should have people who are skilled at this doing your interviews, and you should have people who do it often doing your interviews, because that, like anything else, if you've got somebody who's practiced in it, you're going to eliminate a lot of these pre-hire areas for alleged discrimination. A few other takeaways in the interview or in the job application. Don't collect in case of emergency information. You don't need that prior to having, prior to having them employed. So there's no need to collect it, and collecting that in case of emergency information pre-hire can open you up to some pretty significant challenges. And in this day and age, I'm going to say this, but it seems odd to say, don't take photos. Even if it seems like it would be something that is helpful to you, just don't do it. You don't need photos at pre-hire stage. Finally, if you're checking references, hopefully your interview has gone well and you're at the stage now where you're checking references of a few very good applicants. Keep in mind that everything that was off the table when you're asking an interviewee, when asking an applicant directly, all the stuff that's off the table with them is also off the table with their references. So nothing that, you can't get information indirectly if you cannot get it directly. So when you check references, it helps to have the same person who's doing the interview do the reference checking, because then they're going to be certain to avoid asking all of the inappropriate questions indirectly of a reference. So why do we take such great pains, aside from eliminating potential discrimination claims? It makes sense to engage in all of this thoughtful process, because employers can really limit their potential liability for negligent hiring or negligent retention claims if their employees cause injuries to third parties. Very unfortunately, we live in a time where we have workplace violence, where we have issues that crop up as far as employees causing harm to other employees. And under most states' laws, an employer has an obligation to use reasonable care in selecting and retaining employees. So this creates an obligation from the very get-go for that employer to hire and retain only safe and competent employees. So if you're hiring and retaining an employee that the employer knows or should know is unfit, incompetent, or poses a danger, the employer is going to be potentially liable for damages if that employee causes issues down the road. So in order for an employer to meet their duty of reasonable care when they're hiring an employee, it's important for employers to perform reasonable investigations of their employees during this hiring process to ensure that each employee's past doesn't indicate a tendency that would render the employee unsuitable for his or her position. Employers have to be mindful that certain positions require more thorough investigations. If you're going to have an employee who's working with, say handguns and live ammunition, you better do a heck of a job investigating their background, because they have a very high level of responsibility and a very high level of potential for injury. So the higher that the level of responsibility or potential for injury goes, the more investigation the employer should undertake to make sure that they're staffing that position with somebody who meets, it is responsible, safe, and competent. Keeping in mind the adequacy of the investigation. If, from my perspective, after the fact, if there's a lawsuit, the adequacy of the employer's investigation is going to be evaluated on things like how risky was the position you're looking to fill, how much of an investigation did the employer do, and how discoverable was the employee's past conduct or history. You have to find what you can find. You're not tasked with being a mind reader or finding things that are, buried. You have to make a reasonable inquiry. So as long as you're doing everything that's reasonable, you're fulfilling that obligation. The employer should be detailed and accurate in documenting its investigative practices and policies, because you want to create that record and you want to keep that record. So any investigation that you do, keep, because that demonstrates the employer's use of consistent, reliable, adequate information in hiring and retention decisions. Employers who conduct background checks have to comply with the requirements of the Fair Credit Reporting Act. I think you all know that. It's kind of the bane of everybody's existence, but it keeps everybody on the up and up. Once an employee is hired, there is still the potential exposure for negligent retention. So even if you do everything right and the employee looks like a reasonable employee for hiring purposes, you still have potential for negligent retention if, in the continuing course of employment or discipline that there's misconduct that comes to your attention. If there's investigation into the discipline in regard to employee misconduct, that can help shield your employer from liability for negligent retention. So if your employer takes prompt and consistent measures, you should demonstrate your concern by maintaining qualified and competent employees. You can't turn a blind eye to issues that crop up. And if an employer faces a negligent hiring or retention claim, what you'll be able to do is point to that history, that record of taking employee misconduct seriously, investigating it, and demonstrating the employer's ability to discover certain issues and address those issues. We can't predict everything. I mean, human nature is inherently unpredictable, but you can help shield your employer from negligent hiring and retention claims if you've been reasonable throughout the process and you've kept a history of your reasonable actions. One of probably the most often asked question I get from clients is in regard to non-competes. How do non-competes impact hiring? And what sometimes people forget is that there are non-competes on both sides of the equation. Most employers think of non-competes or other type of restrictive covenants as something to be considered only in the context of protecting a company if the employee leaves down the road. But non-competes really need to be considered on what I'll describe as an incoming basis too. An employer should always be aware of the potential risk that someone who's being hired comes with baggage from a prior employment. And consideration should be paid in the hiring process as to whether an applicant is under valid restrictions that would affect the individual's suitability for the job. And I think that an employer's failure to address legitimate restrictions it really results in opening up a can of worms from the very beginning, because the new employer can be dragged into court as a defendant in a claim for, say, unlawfully interfering with the prior employment's rights. The new employee is dragged in. It just creates a big issue from the very beginning that gets very expensive and very time-consuming very quickly. So if you can issue spot this when you've got an applicant coming in that there is a previous non-compete, you're doing your employer a great service by flagging that issue. Certainly, there are great prospects where an applicant comes in and is second to none, and you want to hire them even if they're subject to a non-compete. That happens. But what you can do is get counsel involved, flag the issue, pass it on to counsel, and you've done your job. You've protected your employer as best you can, and you've effectively passed the buck to the lawyer, which is always a good thing. One thing that comes up also, it doesn't come up nearly as often, but it's very detailed and it's very interesting. So I kind of want to get through this quickly. And if anybody has any questions about employment testing, please feel free to reach out. But I do think we should touch on it at least briefly. Can employers engage in pre-employment testing? Well, it depends on what stage of the application process you're in. If you're at the pre-offer stage, an employer cannot ask disability-related questions and cannot ask an applicant to have a medical examination. There's a very limited exception for a physical agility test. I don't even know when that would come into play in today's age, but if there is a physical agility test that's done at the employer's expense and given to everybody who applies for the job, that can still be done pre-offer. But other than that, medical examinations pre-offer are a big no-no. Post-offer, it gets a little bit different. After you've made an applicant an employment offer, you can make some limited medical inquiry and conduct a medical examination, provided it's at your own expense, the company's expense, in order to get information, again, relevant to the applicant's ability to perform the job. You can't do it just because you're generally curious or some situation might come up down the road. It has to directly relate with the applicant's ability to perform the job as described in the job description. So in most states, as I know it is in Minnesota, in order to conduct a medical examination, the employer has to make the applicant a conditional job offer first. And you have to establish that the condition for employment is that the applicant meets the physical or mental requirements of the job. The condition must be imposed on everybody who is at this stage in the same job category. And again, it has to be limited to only essential job-related abilities. It can include genetic testing. It cannot include, inquiries into the applicant's family's medical history or the results of any genetic tests that came up in that regard. And if for some reason you use a post-offer medical examination to decline hiring an applicant, the reason that you use must be job-related, must be necessary for business, and must involve avoiding a direct threat to health or safety. So these are really sticky issues. If you're going to use a medical examination, either pre-offer or post-offer, again, my advice to you is do it with counsel looking over your shoulder, because this can get sticky very, very quickly. One really important side note, that if you're doing this testing, whether pre-offer or post-offer, an employee's medical information, including the results of any physical examinations, have to be kept confidential. The ADA has narrow exceptions for limited disclosure to supervisors and managers when there's first aid or safety personnel involved. But other than that, there are very tight disclosure restrictions on using all of the information that's gleaned from any physical examination. So please keep that in mind, that if you're going to do this testing, do it with counsel, and make sure that the results are kept confidential. If you're going to use some aptitude testing or performance testing, say for example you're hiring someone at a data processing center and they have to type certain words per minute, it's okay to give them those performance type tests. But while it's still legal, employers should exercise caution again here. These type of employment tests have to be non-medical in nature, and any pre-employment test that really inherently tends to screen out individuals with disabilities can constitute discrimination under the ADA unless it's job-related and necessary for business. So if you're going to use these types of performance or aptitude tests, they have to accurately reflect the skills or the aptitude, the other factors that are being measured. And they should be done very narrowly tailored to meet the job description. Again, this is where a good job description comes into play. We've got a question that popped up: where would a coding test for a software developer fail to determine if they're a more skilled developer at what level they're at? Falls exactly into this category of performance or aptitude testing. This is akin to the words per minute typing test of years gone by. If you've got a coding test that is designed specifically to measure a software developer's skill, you can certainly do that. But I would, again, make sure that your test is narrowly tailored so that you're measuring only the skill that's involved in this particular job description. You don't want the test to be more broadly developed. So make sure that your test is narrowly honed, fits your job description, and if you have this performance type test, you can use it. Scored tests, sometimes we'll go back old school and you'll have the scored pencil and paper tests that aim to evaluate some knowledge or skill or ability, and this could come into, coding issues too, to address that last question. You can use them. You probably think by now I'm going to tell you no, but actually these are fine, provided that they're conducted and used appropriately. It's just like the performance tests, the aptitude tests that we've talked about too. Just make sure that they don't, overly exclude the disabled or somehow improperly show bias toward a certain race or sex or religion or the disability issues, and you'll be fine in using those. If you're going to conduct testing, please remember that there's a duty to accommodate job applicants. Under the ADA in most states, if there's a known disability and the applicant asks for an accommodation, you do have a duty to accommodate, or make a reasonable accommodation for that applicant's testing. You don't have, the test is whether it imposes an undue hardship on the employer to make the accommodation that's requested. So as long as it's not overly expensive or requires some pretty extreme measures, you should make the accommodation for the applicant to conduct the pre-employment testing just like everybody else does. Again, this is one area, if you run into questions, ask your counsel how to make accommodations if at all possible. One of the other, I should have done that earlier, sorry. One of the other big questions that comes up as far as pre-employment testing is drug and alcohol testing. Under the ADA, it's not a violation for employers to use drug tests to find out if applicants are currently using illegal drugs. Under the ADA, a drug test is not a medical examination, and so it's not prohibited. Now, alcohol tests are a different story. Alcohol tests are considered medical examinations under the ADA. So if an employer wants to test for alcohol under the ADA, they can only do that after making a conditional offer of employment. So individuals who abuse alcohol, they can be considered under the ADA to be disabled if they're a recovering alcoholic. So that's why the ADA makes a distinction between illegal drugs, which are never medical, and alcohol, which can be a disability issue. An illegal drug user is not someone with a disability. So if you leave here today remembering that illegal drug users cannot fit the definition of disabled, recovering alcoholic, or someone struggling with alcoholism can. So there is that split under the law. So if you're doing things properly, an employer should follow 3 general requirements for drug tests. Now this relates to drug tests only. The drug test has to be mandatory for all applicants. The results that come in have to be kept confidential in confidential medical files, and the results have to be used in accordance with the ADA as a whole. So you can conduct drug testing, you can do it pre-offer, but you have to make sure you satisfy those 3 issues. If an applicant tests positive for illegal drugs, the employer can ask the job applicant whether they use lawful drugs or if there's any other potential reason that we've got a false positive result. The drug testing that's allowed under the ADA is limited to tests for illegal drugs. So, like many employment actions, drug testing can trigger discrimination claims, so do it very carefully. In Minnesota, we have a much more strict standard than the federal standards, so know the state in which you're asking for pre-employment drug or alcohol testing. In Minnesota, for example, we have to have very specific pre-existing written drug and alcohol testing policies with very specific contents that have to be in place prior to any drug or alcohol testing that the employer is going to request. So that has to be in place. I see we're starting to run short on time, and I want to leave time for some questions at the end. So some other testing that you could ask for or you could think of asking for that I'm going to probably tell you not to do. Lie detector testing is just, it's a criminal offense in Minnesota. That's how strongly some states feel about it. It has its own separate federal act, the Employee Polygraph Protection Act, that prohibits most private employers from using lie detector tests for pre-employment screening. Like any good law, there are a few exceptions, but on the whole, unless there is a very, very strong need for some sort of lie detector test, even at the post-employment stage, lie detectors have a very limited place in the workplace now. So certainly pre-employment, I would say almost never. Unlike fingerprinting, there's no federal or state restriction that currently prohibits, that I know of, that prohibits a private employer from requiring applicants to undergo fingerprinting. But if an employer decides to fingerprint applicants, it should create a policy and apply that policy uniformly so that you're not discriminating against certain pools of applicants. One of the things, after you've done all of your pre-employment testing, and if you decide to make an offer, one of the things you need to keep an eye on is whether the employment is employment at will or a contract. Usually by default, employment status is employment at will, which means that the employer or the employee can terminate the relationship at any time, with or without notice, with or without cause. But if you want to keep that at-will employment status, you need to make sure that along the way you don't have any language that could be considered contrary to the at-will employment. So you don't want to talk about arbitration agreements or non-competition or confidentiality agreements if it doesn't fit the employee that you're hiring. One size does not fit all, and you can destroy an at-will employment relationship and give the employee more rights than you intend to by including unnecessary language. If you do want to use an employment contract, if you've got, say, an officer or director or somebody you want there for a very specific time limit, make sure the time limit is stated in the employment contract. That's no longer an employment at will situation. If the contract has a time limit, please make sure you keep that employee's employment to that time limit. If there is if the employee stays on after the time limit, there's a presumption of automatic renewal. So if for some reason you've got an employee who's subject to a contract that ends on December 1st, if it was a year-long contract and they're still working on December 2nd, December 3rd, all of a sudden they're outside the time limit for that original contract. If they wanted to, they could make the argument that you've now extended their contract for another year. So be very careful if you are using employment contracts that you keep the terms and conditions contained to what's in the employment contract. A common way that employers communicate information to potential hires is through an offer letter. I always call these a trap for the unwary. I understand it's a good vehicle to get the new hire, the person you're trying to hire, information like starting salary and start date and bonus information. But make sure that they don't contain information that suggests permanence or specific duration for the employment relationship. Even if you're trying to include general niceties, sometimes those have been construed by the courts as saying, well, that if you're talking about annual salary, that implies that they'll be there for more than 1 year. So each word in an offer letter counts. Don't include more language than is needed to advise the incoming employee of the terms and conditions of the offer. Final step, after you've made your offer letter, you have someone who's going to come on board. Are there any things that you legally have to report once you have a new hire? As I'm sure you're all well aware, you've got to fill out the federal I-9 form within 3 business days of hiring to show that an employee is authorized to work in the United States. Minnesota, like many states, uses the E-Verify program. And then also, when you're reporting new hires, both Minnesota statute and certain other states, and then there's a federal statute that requires all employers to report newly hired or rehired employees within 20 days of each new hire and to convey certain information. So just be aware that, from start to end, there are very specific issues that you should keep an eye on, that nothing as far as these initial stages of recruiting and hiring should be taken for granted, because like I said, if we get into bad habits, those bad habits can lead to potential liability for your employer pretty quickly. So hopefully I've given you some information to develop good habits and to ask the right questions, and you can still figure out if this job applicant is the right applicant for you. You just have to do it through the right mechanism. Okay, so that being said, if you have any questions, I certainly welcome those. I see that Deanna has asked a question, is there any federal regulation regarding asking about criminal background if you're a federal contractor or Tier 1 subcontractor, noting it is still legal to ask in our state and city? I'm not aware right now of any federal regulation. That being said, I think that particularly if you're a multi-state employer, um, the the concern is that if you're asking about criminal background early, that you could violate, even if you're not subject to federal requirements or you're not subject to, your state's requirements. If you're asking about criminal history too early in the process, you could run afoul of another state's concerns. So, if you have questions, certainly in your particular situation, it's very important to you to ask about criminal history early. Contact your own counsel. But again, unless there is a real urgent need for you to ask for criminal history early in the process, wait until after you've extended a job offer. That's my advice. There's another question. What would you say instead of annual salary? Just say your salary. One of the things that in an offer letter, if you're conveying information about when and how someone will be paid, use language that talks about, your, for example, a statement of salary. You could make it in terms of a weekly, like you'll be paid X number of dollars weekly, or semi-monthly per payroll, period. Talk about it in the short term instead of the long term, because if you're talking about annual salary, there is going to be an expectation of more than 1 year. There can be an expectation of more than 1 year. So that's my suggestion, is talk about it, how much you're going to be paid per pay period. On the at-will side of things, are you saying, there's a question that asks, are you saying that we should not have an arbitration agreement? No, I'm not saying that. What I'm saying is that you should not include it in an offer letter. You should not include it probably anywhere other. If you're going to talk about arbitration, talk about it in your handbook and talk about it clearly as one of many policies that it does not intend to interfere with the employment at-will arrangement. So do it in context with the necessary disclaimers. I don't think it's, I've not seen a situation yet where it's necessary with an at-will employee to talk about arbitration before you're distributing your employee handbook. Employee handbooks are the topic for another day, but a good employee handbook will have arbitration in there, and I think that's the appropriate place for it rather than an offer letter or anything prior to hiring. Tracy asked, we are considering manual dexterity testing. Any concerns with this? To the extent the manual dexterity is part of the specific job requirement and you make that a known condition of the job requirement, so it's posted and everybody knows that this will be a specific job requirement, I do not have an issue with the manual dexterity testing. I think that is, as long as it's tailored just to test the issue or the skill set that's going to be required for the job, everybody knows it's going to be tested and that it's a job requirement, I think that's entirely fine. Any other questions?
I think that's all we're seeing come in right now, Heather. Okay. Can you go ahead and flip forward to the SHRM and HRCI slides? If anyone else has any questions, go ahead and send those in. But yeah, I just wanted to get those up. Thank you for your presentation, Heather. Really appreciate it.
Thanks, everybody, for attending.
Yeah, I'm not seeing any other questions. No, yeah, I'm not seeing any other questions. So I guess if you have any other thoughts before we go, Heather?
I don't. There's a lot to pack in here, and I know I talked fast anyway, and I've talked particularly fast today. So if there's any follow-up questions, certainly I would invite anybody who has questions can feel free to contact me directly.
Yeah, let's go ahead and I think that should be good for, yeah, throw up the last slide that has your info, all of it. There's one more slide, I think, Heather.
There we go.
Yeah. So there's Heather's info. She's in Minnesota. Author of the Minnesota Human Resources Manual If you're in Minnesota, check that out. Heather, I did see another question. In our drug and alcohol policy, it states that we are going to drug test all applicants. We plan on doing this. Should I mention it in the interview?
I don't think it hurts to mention it in the interview. I would make sure that if you're going to mention it in the interview, you mention it in every single interview, so that you're not only mentioning it to certain applicants, because that could give them the impression that there's some discriminatory statements being made. I think if it's on your application that indicates you're going to test everybody, I don't think it's necessary to do it at the interview stage. But again, just make sure that if you're testing, that you're indicating that everybody is being tested. It's mandatory testing for everyone, and that there are no exceptions, because I think that lets everybody know you've got a policy, that you're applying the policy across the board, you're applying it appropriately, and no one should feel singled out by the application of that policy.
Okay, one more question. What should I do if a manager makes a bad statement to an applicant?
Certainly if you're in the interview, find a very graceful way to say, well, that's not quite the case. I just want to make sure that, I'm getting you the correct information. Issue the correction if you're there. If you find out about it after the fact, obviously it is what it is. You need to make sure that the manager, whoever is conducting the interview, knows that you can't be asking that question, or you can't be soliciting that information, and here's why. At that point in time, it kind of, to use the old phrase, the horse has left the barn. So I wouldn't pursue it. If you dug a hole, stop digging. So I wouldn't issue any further statements on it, but I would make sure that your folks are trained so that it doesn't happen again. If for some reason someone brings an action or makes an allegation based on the misstatement that occurred, face it head on. Involve your counsel early so that they can get a handle on it. But as to the extent you can correct it immediately, and after the fact, engage in some good training.
Okay, thanks, Heather. I think we're going to go ahead and wrap it up here, but really appreciate your presentation. Thank you, Cozen O'Connor, also, and everybody who joined us today.
Thanks, Eric.
Yeah, thanks. For HRSimple.com and Cozen O'Connor, thank you for attending, and we hope to see you again.